Hello everyone. In this presentation, we will discuss about the causation of crime. Now what is this about? Supposing A fires at B. In order to escape from the bullet, B moves back and falls in a pit where his head hits a stone and he dies of head injuries. Can A be held liable for murder of B? Here, A has an intention of causing B's death and voluntarily fires at him. But did B die because of a bullet injury? No. The death was because of the head injury. That is, the cause of death was not the bullet injury but the head injury, and therefore A cannot be held liable for causing death of B but only for an attempt to cause his death, that is, an attempt to murder. A man would be liable for a crime if he caused the guilty act with a guilty mind. He would be liable for the actus reus, that is the guilty act, only if it is shown that the actus reus would not have occurred without the participation of the accused. He would be liable only for those consequences which he had foreseen or should have foreseen while doing the act. In the above example, A, when firing at B, intended to kill or intended to cause an injury which is likely to kill B. But he never foresaw that B would fall in a pit, suffer head injury and succumb to it. Hence, he would not be liable for causing B's death but only for attempting to cause his death. A man may be criminally liable for an act even if he does not physically participate in it or participates indirectly. Where A provokes B to cause injury to C and B causes injury to C, A would equally be liable for causing the injury as an abettor, though he had not participated in the commission of crime. Similarly, where A mixes poison in a drink and asks B to offer it to C, which B does and C dies, A would be liable for causing C's death, though his participation is indirect. But if there is an intervention of another person and that intervening act becomes the immediate and direct cause of the consequences, he will not be liable for the consequences. For example, A fires at B and B is injured and becomes unconscious. C, believing that B is dead, burns his body, resulting in the end of B. Here will A be liable for B's murder? As the death of B did not occur on firing, though he was seriously injured, A will be liable only for an attempt to murder. Will C be liable for causing B's death? Unless he burns it knowing that he is still alive, he will not be liable for murder. If he had burnt the body believing it to be dead to help A in concealing the crime, he would be liable only for screening an offender and not for murder unless they jointly participated in the commission of a crime. Sometimes a wrongful act may be done by the accused and it may be followed by improper medical treatment or want of proper care by the victim, or the victim may refuse to undergo proper or recommended treatment due to various reasons which result in the death of the victim. Now, will these intervening factors relieve the original wrongdoer of his responsibility for victim's death? Let us see. Where a person inflicts a wound which is mortal, that is, injury which is likely to cause death, even where the wound might have been cured by skillful treatment, but it was not, and hence the victim died, the person would be liable for homicide. Supposing A stabs B and leaves him with the wound at the spot and escapes. B does not die but lies unconscious with the wound for 2 days without any attention and bleeds to death. Now, had B been taken to a hospital and treated for the wound, he would have survived because the wound inflicted would have healed with proper and timely treatment. A would still be liable for B's death because here the wound was still the operating cause of death. If the wound inflicted is non-mortal and the victim dies from improper treatment, it is not homicide if the wrong treatment or medicine is the immediate cause and operating cause of death. For example, A hits B on his head with a stick causing bleeding injury. B is taken to the hospital and is given penicillin injection and his wound is dressed. The wound heals, but B dies due to accumulation of water in his lungs because of penicillin to which he was not compatible. Here, A, who inflicted the wound, will not be held liable because the wrong treatment and not the wound was the operating cause of death of B here. But supposing A inflicts a wound to B with a knife, which is not in itself mortal, and he is taken to the hospital and is treated for the wound. Because of gangrene setting in, B dies. Here A is liable for B's death because the wound that is inflicted by him is still the operating cause of the death. Thus, so long as the injury inflicted remains the operating cause for the death of the victim, irrespective of whether he is treated improperly or not treated at all, the accused, that is, the person who inflicted the injury, would be liable for the act. Even where the victim does not get skillful treatment on time, or even where the treatment is available, the victim is unable or unwilling to resort to them and suffers death, the person inflicting the injury will be liable for causing the victim's death. When the wound, which is the primary cause for death, sets in motion some other cause like gangrene, which ultimately results in the death of the victim, so long as the wound inflicted and death caused are sufficiently connected as cause and effect, the person inflicting the injury would be liable for the death of the victim, irrespective of whether the wound could be cured by treatment or not, because the wound remains the operating cause of death. Even where the victim neglects or refuses to undergo treatment or does not take proper care of himself after injury, the accused will be liable for the consequences. Contributory negligence, wherein the victim also by his negligence contributed to the injury suffered, cannot be a ground for mitigation of liability in criminal law. When the accused inflicts an injury by doing a wrongful act, he cannot plead that had the victim not been negligent, he could have avoided the injury. For example, where A was driving rashly and negligently on a busy road and hit B, who was crossing the road without following the signal for pedestrians, A will be liable for negligence and cannot plead that B, through his negligence, contributed to the injury suffered, and had he been careful, he would not have met with the accident. However, contributory negligence is relevant for deciding the quantum of punishment to be imposed. Now, when a person intentionally takes part in the commission of a crime, which would have occurred irrespective of his participation, he would still be liable for the crime. For example, A sees B, C, D, and E beating X with lattes. A joins them and inflicts a blow. X dies because of the blows inflicted on him. A will be liable for the act, and he cannot plead that by the time he joined, X was almost on the verge of collapse, and irrespective of whether he inflicted the blow or not, X would die and his assistance was superfluous. His liability would depend on whether he was a party to the plan or just joined the event at the point of time. Thus, in order to hold a person liable for a criminal act, in addition to proving the actus reus and mens rea, it is important to establish the causal connection or cause and effect relationship between the act of the accused and the injury suffered by the victim. Thank you.